Hello and welcome to Liberty Law Talk. I'm your host, Richard Reinsch. Liberty Law Talk is featured at the online journal Law and Liberty, which is available at lawliberty.org. Today we're talking with Keith Whittington about his new book, Repugnant Laws, Judicial Review of Acts of Congress from the Founding to the Present. Keith Whittington is the William Nelson Cromwell Professor of Politics at Princeton University. He's one of our leading constitutional scholars, having written books on the judicial branch, on constitutional interpretation, among other subjects. He also recently wrote the book Speak Freely, which he appeared on Liberty Law Talk to discuss. So Keith Whittington, welcome back.
Thanks for having me.
I was thinking about the book, and I think it's instructive here to read the full subtitle, Judicial Review of Acts of Congress from the Founding to the Present. I think this book will be seen as a landmark in studies and judicial review scholarship, given the scope of what you've done and the achievement here, an empirical review of judicial review of congressional statutes, either striking them down or upholding them in the face of constitutional challenge. Maybe talk a bit about what you did, your research methods, which are certainly impressive, and what you were trying to achieve.
Yeah, so it was now quite a few years ago. I was talking to an editor at the press about potentially doing a book on the history of judicial review. At the time, the Rehnquist Court had come under a lot of fire for striking down a lot of acts of Congress. And was being heavily criticized for being so activist. And so we were trying to be some interest in trying to think about how the court had used the power of judicial review over time to think about Congress. And initially, I thought I could put that together pretty quickly. There'd be a fairly short book. I had some thoughts already, given other work I had done on sort of the relationship between the court and other political institutions. So I thought it'd be an interesting thing to do. And then when I sat down and started really thinking more carefully about, well, what would the book actually look like, I realized I had a pretty good idea about the highlights of the court's history in striking things down, but knew very little about when the court had upheld cases. We just don't talk about that very much. It doesn't get a lot of play in the history books. There's a handful of cases we pay attention to. And so that seemed like a big dark area that one would need to think about more carefully. I thought it'd be an important part of the story. And then I also started thinking that there was just an awful lot of sort of routine, everyday instances of striking down laws of Congress that likewise you just don't learn in a constitutional law class, for example, or not generally covered in the histories. And so I realized that my sort of image of how the court did exercise judicial review was probably pretty limited and skewed. And so eventually I decided, well, the only way of really doing this was to try to cast a wide net and be more comprehensive about trying to identify what were all the cases where the court had substantively reviewed acts of Congress. And it turns out that was a harder task than I initially imagined.
How many cases did you end up including in this study?
At the end of the day, it's a little over 1,300 cases altogether. The unfortunate part is, in order to find those 1,300 cases, I wound up reading tens of thousands of cases in order to try to identify which ones might plausibly involve substantive evaluations of the constitutionality of a federal statute. There is a list that the Congressional Research Service maintains that was originally put together by a predecessor of mine at Princeton University, a constitutional historian named Edward Corwin in the mid-20th century, put together a list of cases in which the court had struck down acts of Congress. And so that at least seemed like a starting point, but I was worried that list actually had left stuff out. There were some reasons to think that it was not complete in itself, and so I didn't want to rely on it. And then, of course, it didn't even try to count cases in which the court had upheld statutes. And so So I just started doing a lot of electronic searches as well as reading of secondary sources and the like in order to try to find every case that might plausibly have something to do with congressional statutes and the Constitution, and then just started reading them in order to try to see, okay, well, which ones actually involve instances of judicial review.
Let me ask you, and I know you focus in the book, Judicial Review of Acts of Congress, set forth in the subtitle. But let me, and I think a lot of listeners probably have this question on their mind. So we have a Republican Constitution, ultimately accountable to the people, the actors who are empowered by it accountable to the people. And yet we have this strong element, almost an aristocratic power, you might say, over those public laws, that being judicial review. How did we come to get this power? How was it strengthened? How was it formulated? Because I think a lot of people wonder why would we even have that?
Yeah, it's a totally fair question. And of course, over the course of American history, lots of people questioned where we got this power from and why we ought to continue to have it. And in fact, that gets tied up with questions about, well, what's actually the historical record and how often the court struck down laws. And so there was a time when it was a quite active political as well as scholarly debate about how often the court had struck down acts of Congress, because the populists and progressives argued that the court hardly ever did that. And so it was particularly illegitimate if the court were to strike down acts of Congress. And more conservative politicians and lawyers and scholars argued, no, the court had done this fairly often and had done this consistently all across American history. And so as a consequence, we ought to think it was fairly legitimate for the court to continue doing it over time. I think it's pretty clear the founders, not only in drafting the Philadelphia Constitution, but also in drafting various state constitutions, anticipated something like the practice of judicial review, but I don't think they understood what the contours of that would wind up looking like. They certainly didn't imagine the importance that eventually assumed within the constitutional system. I dedicate a chapter in the book to trying to walk through some of that early history in the states as well as in the federal government of how the court, our courts started exercising judicial review in the United States and how that was thought of, in part because it seemed like the right starting point to try to think about then how the court specifically wind up using this against Congress. And I think the power does emerge sort of gradually, and it emerges out of this sort of natural thought that the people, through their representatives, adopted a fundamental law known as the Constitution. There are legal restrictions built into that fundamental law, and courts are charged with interpreting and applying laws. And so when a proper case comes before them in which government officials are thought to have done something that falls outside the bounds of what the fundamental law says they have the authority to do, then the thinking was courts ought to not apply a statute, for example, that was contrary to the Constitution, but instead ought to enforce and apply the terms of the Constitution itself. So the basic logic of judicial review emerges quite naturally out of the idea that courts apply law. The Constitution is a kind of law. The Constitution, moreover, is a superior law to legislation and mere statutes that a legislature might pass. And so courts were obliged to enforce the Constitution instead of a statute.
Well, there's something too, it seems to me, of, the early, say, colonial judges or so early American Republic judges, particularly the new state constitutions after the Declaration of Independence. There's something about writing things down in America that to my mind logically extends to judicial review. That because you've taken the time to write it down, to discuss it, debate and ratify what you're going to write down, it stands to reason that you're going to want to have some way of upholding it in a judicial way.
Yeah, I think it helps. It may not be a necessary condition for having judicial review that you have a written constitution, but but it becomes important, and judges rhetorically use the fact that the American constitutions are written down to help leverage the power of judicial review when they start exercising it, because judges start saying, look, unlike the English Constitution, for example, which is unwritten, the American constitutions are written, and as a consequence, they have a certain clarity to them, that they include certain fairly specific rules, and when legislatures violate those rules, judges can't just ignore that because the text of a constitution is particularly determinate in a way that maybe is not so true in an unwritten constitutional tradition. It's also true, I think, that writtenness of the American constitutions was tied up with the fact that the people in their sovereign capacity had legislated the Constitution into existence, that this was not just a political tradition, this was not just a description of what government officials did in practice. This was a statement about what the rules were that the government had to live by, that the people themselves had put in place and had documented and embodied in the form of a written constitution. As a consequence, judges had an obligation to pay attention to what the people had said were the most fundamental rules in the political and legal system. And so I think the writtenness of the American constitutional text helped get judicial review off the ground. It was sort of a key part of what judges talked about and why they needed to engage in this practice early on. And it was part of what other government officials recognized as why judicial review, in fact, was a legitimate thing for judges to do, was in part because they also recognized that, there are constitutional rules, they're written down, they're relatively clear, you can't just ignore them. And yes, they, in fact, are the supreme law in the system because the people had made it so.
I want to get into your analysis of how the court in different historical periods shaped congressional authority. Before we do that, two scholars that loom large in your study here of judicial review, Ronald Dahl and Alexander Bickel, both of whom had contrasting views of judicial review, but well-known views that have shaped the way we think about this field. You disagree with both of them. Maybe talk about that.
Sure. So I thought they were useful foils for thinking about judicial review. They're very prominent figures in talking about judicial review. Dahl has had a tremendous influence among social scientists, in particular, thinking about judicial review. He was one of the leading political scientists of his day from the late 50s through really the early 1980s. A giant figure at Yale University. He mostly did not write about political institutions or judicial review. He is mostly focused on voting behavior and interest groups and other features of American politics. But he wrote one article in particular about judicial review, and he wrote it sort of in the wake of Brown v. Board, and consistent with how he thought about politics in general. His orientation and thinking about judicial review was to imagine that judicial review probably is not all that important because in part Dahl didn't think institutions in general were all that important. He thought that far more important were sort of how people thought and how they behaved in practice, what voters wanted and that kind of thing. And so he thought it would be very surprising if a set of written legal rules enforced by politically appointed judges would actually be all that consequential in the system. And so he wrote this very straightforward article thinking about the history of judicial review, pointing to the fact that judges were ultimately appointed by politicians, and he thought the implication of that would be that judges would hardly ever get in the way of what politicians wanted, because politicians were putting judges on the bench in order to approve the laws that those politicians were passing, not to veto the laws those politicians were passing. By contrast, Alexander Bickel, who was a giant figure in Yale Law School at around the same time period, was extraordinarily influential among law professors and lawyers in thinking about judicial review. And his concern coming out of the New Deal experience was that judicial review was a deeply anti-democratic institution. It was the capacity of a set of elite, unelected actors to set aside the duly passed laws adopted by democratic majorities. And he thought that was very troubling and hard to justify in a broader democratic system. And so there's just this real interesting tension between sort of how they imagined judicial review working and what implications they drew out of that. Dahl was much more focused on the empirics, how judicial review actually worked in practice. Bickle was much more concerned about the normative issues. How do we legitimate this kind of institution? But there are interesting tensions between them, and one concern of the book is to try to paint what I think is a more realistic picture of how the court is actually operated that doesn't quite match either the picture Bickle had in his head about how judicial review worked or the picture that Dahl was sketching out about how judicial review worked.
So maybe we can get into that. Things that, say, the early court and the early republic, how is it shaping, thwarting congressional power? You also note that it's engaging in nation building as well. Maybe talk some about that.
Yeah, so one of the striking things I think about the book and the project was discovering just how much judicial review was occurring early in the nation's history. If you know much of anything about American constitutional law and American constitutional history from this early period, the standard narrative is that the court only struck down federal statutes twice before the Civil War, once in Marbury versus Madison during the Jefferson administration, first instance in which the court struck anything down, and then in Dred Scott just before the Civil War. And that was it. And I think that's just wrong. I think, in fact, the court was much more active in reviewing federal statutes than that implies over the course of these decades, that, in fact, the court enforced constitutional limits against Congress in lots of cases during this early period. And those cases have largely been forgotten by history, in part because they were not very politically exciting cases. They involved relatively unimportant legislation. They didn't have big implications politically or from a policy perspective. But they were building the practice of the courts being open for business to hear constitutional concerns and enforce the constitutional rules when, in this case, federal legislators violated those rules. And so I think the practice of judicial review doesn't just come blasting into existence with Marbury versus Madison, for example. It's not this bolt out of the blue in the context of Dred Scott decades later from this sort of forgotten institution. Instead, it's a practice that gets developed slowly and gradually across decades by the court, sort of hearing pretty mundane cases, making fairly routine and relatively uncontroversial decisions about the constitutionality of federal laws over time. And a lot of those decisions were about what I think of as nation building and state building. They are about trying to explain why Congress, in fact, has the power to do stuff. And then also try to be clear about what the rules are that Congress has to follow when trying to do stuff. But part of what the courts engaged in that process in those early decades is emphasizing national authority, emphasizing the scope of what Congress can do, and explaining how they can do it, which helps make Congress a more powerful institution than it might otherwise have been.
So let me think about it this way. During the debate over constitutional ratification, famous dialogue between Brutus and Publius over judicial power, Brutus argues one reason among many why you should reject the Constitution is the power of the judicial branch that it will hold over interpreting these largely general terms of the Constitution, and it will gradually expand federal power through judicial interpretation of it. And Hamilton, as Publius responds, famously, least dangerous branch will generally let law stand only if they are, manifest tenor or something like that is in disagreement with the Constitution will be struck down. And he tries to blunt Brutus. Sounds like what you're describing, though, gives the nod to Brutus in a rather important way in terms of how the early court is shaping federal power.
Yeah, I think the later court as well. I mean, I think Brutus was definitely onto something. I mean, I'm not sure that necessarily makes the court, and especially dangerous branch. I mean, part of what Brutus is concerned about is that the court will articulate these very nationalistic principles that give Congress lots of power, and he is very worried about how expansively the court would likely read the Constitution and how that would encourage Congress to do lots of things and become a more powerful institution. I'm not sure how much causal significance the court actually has in making Congress do things they might not otherwise have done. But Brutus was certainly right about what the court will mostly wind up doing across American history is explaining why it is that Congress can do whatever it wants. And the court is mostly smoothing the way for Congress to exercise legislative power. Both against the states ultimately, but also against individuals and be more active in American society more generally. And so I think Brutus was certainly right to warn that the court would have this very nationalizing, federal aggrandizing inclination, and that would be expressed through American constitutional law. And if we pay attention to the cases in which the court is upholding acts of Congress, that's certainly what we see. That the court, even in the periods in which we think of the court being extraordinarily activist and striking lots of stuff down, the court, in fact, is mostly spending its time upholding acts of Congress and telling Congress that the things they want to do are perfectly fine, which means that most of the time in the most controversial cases and the most controversial kinds of statutes, the court is, in fact, giving Congress a thumbs up and says they're doing fine.
So I think you say, I forget the number, I'm sure you know, it's like something like 3-1 when statutes are challenged constitutionally, the court will uphold the statute.
Yeah, that's about right. Across the court's history as a whole. I mean, one thing that's interesting about the recent court is that they're upholding a lot fewer statutes than they used to. So now it's much more the case that when the court agrees to hear a case.
When you say recent court, do you mean Roberts Court, Rehnquist Court?
It mostly actually is Roberts Court.
Okay.
So this is a very recent change. I mean, it gradually it's gradually become more true over the course of a few decades. So you saw aspects of it during the Berger Court and the Rehnquist Court, but really there was a pretty sharp shift with the Roberts Court, where the Roberts Court has just not agreed to take very many cases in which they are inclined to uphold the congressional statute. They mostly just allow those cases to be settled in the lower court. So it's not that the court system is not upholding congressional statutes, but the Supreme Court doesn't feel the need to weigh in those cases the way they have through most of American history. So now it's much more true that if the court agrees to hear a constitutional challenge to an act of Congress, Congress's odds of losing that case are actually pretty high. But through most of American history, if the court was hearing a challenge to Congress, Congress was almost always going to win.
Yeah. No, I'm always curious, though, and I know you haven't done the type of just like a pure numbers crunching study, obviously, when we talked about reading all these cases, and this book is incredible analysis of them. But it is, so we say like 3-1, it's upheld congressional statutes, but you don't need a lot of cases. A lot of cases striking down statutes to alter the course of the republic or to alter the course of our politics. Striking down the National Industrial Recovery Act be one instance, marking a trajectory not only, really in how the court's going to interact with the New Deal and with this enlargement of federal power, but also say striking down the Defense of Marriage Act more recently, which injects something into our politics. Maybe, I don't know, did you have those thoughts as you were doing your work that, I mean, it's upholding, but yet what it's striking down could be 10 times more, orders of magnitude more important?
Yeah, I think that's totally right. And it's one of the hard issues to grapple with in trying to think about these studies. And so I should emphasize that the backbone of the book was really this assembly of a data set of what are all the cases, actually just trying to create the inventory, what are all the cases in which the court has subsequently evaluated a federal statute and either upheld it or refused to apply it because of constitutional problems. And that data set's now publicly available, and others can use it, and I hope they do. That took a long time to assemble. But the book tries to make use of that sort of backbone and to think about sort of what are the big patterns across American history. It has some figures and graphs to reflect that, but mostly the book tries to take a more qualitative approach. It's trying to work through the historical cases and try to think about them more qualitatively. It's not just and it's not a statistical analysis of these cases primarily. And so I think it's really in that qualitative work where you can start trying to think about how important are these cases, relatively speaking, that each case is not the same. It has different implications from a political and policy and legal perspective. And so let's try to think that through. And certainly it's the case that some cases are much more important than other cases. But that's true both for the cases upholding laws, but also for cases striking laws down. That there are some cases where the court strikes things down where they just are not that important. It has relatively few consequences. Other cases where the court strikes things down and it's very important. And that's also true about when the court is upholding laws. Some of those cases are relatively unimportant, but some of them are quite consequential about what it means. And so it's worth trying to assess those differences. I think the thing that I have a much harder time, I think, getting a handle on is what are the political repercussions in terms of future legislation from some of these courts' actions. And so, for example, you can imagine a case in which the case itself is relatively small, maybe even the policy the court is evaluating is not that consequential, but the legal rules that the court puts in place has big consequences for the kinds of legislative proposals that Congress might think about down the road. And it's hard, I think, to really get much of a handle on how consequential that might be. So how many things did the court take off the political agenda as a consequence of some case they decided 10, 20 years ago, even when that case itself didn't seem all that important, but it may have big ramifications down the road. So, I think that's hard to assess. And I think the book tries to talk about that a little bit, but I think that is just a hard problem.
So thinking about an era when the court is generally perceived as being quite activist. Now, of course, a lot of this is state legislation, so it falls outside of your scope, but you do write about the Lochner era and that particular period and the Gilded Age and the rise of corporate capitalism, and then the push for various types of social legislation. Maybe talk about that in your research from that period.
Yeah, it's an interesting period, and it's one that's gone through a lot of revisionism over a couple of decades now. People really rethinking what not only the U.S. Supreme Court was doing, but also what a lot of state courts were doing during that period. Just how aggressive were they in striking down laws? How innovative were they in developing new constitutional doctrines during that period? My book in this case turns out, I think, a slightly interesting angle on this period, in part because a lot of the most famous cases we think about from that Lochner period, where we think of the court being very activist in attacking legislatures, a lot of those cases involve state legislatures and state government officials, not necessarily Congress itself. And so one thing I think is interesting that emerges out of the book is the extent to which during this period that we think of the court being very obstructionist and activist, when we think about how the court is responding to what Congress is doing, it doesn't look nearly that obstructionist or activist. It's upholding an awful lot of stuff, including a lot of very innovative things that Congress is doing. The administrative state is growing by leaps and bounds in the late 19th and early 20th century, and the court, for the most part, is giving its approval to those things. So it nibbles around the edges. It constrains what Congress is doing on a few things, sometimes sort of famously, it bites into what Congress is doing in somewhat significant ways. But a significant part of what the court's doing during this period is upholding and encouraging Congress as it's developing a big state. And this is a relatively conservative court. It's clearly conservative in lots of ways, but it's a conservative court that is not overwhelmingly hostile to the rise of the progressive state. It's mostly helping the progressive state along.
So this sort of ties into, I think, a general observation you make in the book about your research that, and we were getting this earlier with say Dahl, and Dahl said, as you said, we wouldn't expect them to find the court striking down legislation because its political allies would have put it into place, and that's how they in fact got onto the court. But we might find them being willing to strike down legislation that preceded them by decades by people that weren't their political allies. And you say that's wrong. What we find is the court being very savvy and being sort of partners in political power and looking at, say, fault lines or fissures within a coalition that they tend to identify with and sort of working in those margins.
Yeah. So I think one of the big themes that emerges out of this is a sort of modified version of Dahl's basic concern. That Dahl is certainly right that politicians do not appoint justices onto the court who are hostile to those politicians' fundamental agendas. Right. So presidents do not go out and put people on the court that they think will then constantly be obstructing the things the president is trying to accomplish. And so for the most part, presidents are nominating and senates are confirming a set of individuals who are well within the mainstream of the coalition that put them there. They may have differences across the partisan or ideological divide. So if it's a conservative coalition putting justices on the bench, they're going to be putting conservatives on the bench, and the same with more liberal coalitions. But Dahl's totally right that it would be very weird if you're winding up with a court that was implacably opposed to sort of the mainstream policies of their period that are emerging out of Congress. Because how did those people ever get there holding such non-mainstream views and ideas? On the other hand, I think Dahl underestimated the extent to which partially the court does, in fact, have some independence. It's capable of making decisions on its own. It's not just rubber stamping and taking directions from other political actors. And that has consequences. The judges have their own priorities and their own values they're trying to implement and enforce. And I think Dahl also underestimated the extent to which politicians don't always mind having laws struck down, even laws and policies that they are signing off on. Mm-hmm. And so one routine feature of how judicial review gets exercised in practice is that the court is finding those themes in political coalitions. They're playing off tensions within ideological commitments or within political parties and exploiting them and sometimes enforcing ideological commitments or a set of constitutional values that politicians are giving lip service to, but don't always respect in practice. And judges take advantage of that by giving some teeth to things that politicians in practice may not be so careful about observing on their own.
Yeah, when I read that in your book, I thought about George W. Bush's statement when he signed the McCain-Feingold campaign finance law. And he said, I have to sign this, but the courts are going to tell us anyway. And I always thought that was a convenient way for him to sign this legislation that we were told was, positive legislation, getting money out of politics, but yet wink, wink, thinking, as many did, that the court would sharply limit it.
Yeah, I think that's become
which strikes me as really immature Republican small r constitutional politics.
Yeah, and I think it's become a more common feature of presidential politics. I mean, that particular dynamic is one I tried to explore in an earlier book, Political Foundations of Judicial Supremacy, which in particular was focused on how presidents relate to the courts and the exercise of judicial review and and just how hostile are presidents to this practice. And part of the thrust of that book was to say presidents tended not to be that hostile to judicial review. They were often cheerleaders for the court, and the court striking things down. And part of the reason was this one, that part of what presidents are doing as politicians and as coalition leaders is they're trying to manage a difficult political environment. And one way they manage that is to do things like sign complex pieces of legislation that may be popular or that may serve certain political interests, but they think has all kinds of constitutional flaws in it. And instead of vetoing that legislation, which I think would be the more appropriate thing for them to do, they instead sign that legislation into law and then lobby the court or encourage the court to scrutinize that legislation and excise the parts that are constitutionally faulty.
Mm-hmm.
So George Bush did it in the case of the Campaign Finance Act. Bill Clinton did it in the case of some regulations of the internet, for example. But it's not a totally uncommon feature, and more we see examples of that occurring in the 19th century as well. So it's also not something that only recent presidents invented. It's something that politicians have been doing all through American history. As soon as the court started exercising judicial review, politicians realized there were some advantages to them to be able to have courts cut out the bad stuff.
Yeah. Thinking, just as we were talking, we have this idea of the Lochner era. You've introduced some complications to that empirically, and yet we have this idea largely because of a couple of cases, Lochner being one of them. Also, I think the way progressive legal professorial class continues to play up the period as well in their scholarship. But it seems to me also it's Lochner, but it's also a doctrine in Lochner, substantive due process, which enlists great power in the judiciary that they can use as they see fit. Even though it's just one case, but it's an overall doctrine, I guess is my point.
No, it does. I mean, it's a powerful doctrine. It has lots of implications for how the government works, and as a consequence, gives judges a fair amount of discretion to involve themselves in how government works. And so it was a consequential doctrine in its day, and there are modern forms of it that are quite consequential as well. Part of what the revisionist history of the Lochner period emphasizes is that set of doctrines the court was using during that period had firmer foundations than I think progressive historiography tended to give it credit for. It's also true that courts, in fact, struck a lot fewer things down using those doctrines than progressives tended to emphasize. And so progressives would highlight the handful of cases where judges actually struck stuff down. But if you start looking at even those substantive due process cases, in particular, you start looking across a large number of them, what you find mostly are judges saying, I see the complaint here, but this law doesn't actually violate those concerns, and so they uphold it. And so it's a doctrine that can have some teeth, but was often not applied in a way that was very restraining to what governments were doing. And you see a little bit of that in the case of Supreme Court review of congressional statutes as well, but not as much. The court doesn't use substantive due process all that often against Congress, and so it is much more salient in thinking about how courts are reviewing what state legislatures do than reviewing what Congress has done. But the court certainly had other doctrines as well to potentially limit what Congress was up to.
I want to get, you have a chapter, the Constitutional Revolution, starting with the New Deal. How does that change judicial review?
Yeah, it changes it in a few ways. I mean, part of what I thought was interesting as this project was coming together is it puts the New Deal story in a somewhat different context. I think the basic outlines of the New Deal story are, of course, familiar, and I think the book reinforces those outlines of the court striking down a lot of really important legislation in the 1930s and in a very contentious period, and then the Democrats pushing back aggressively, and eventually the court caves in and starts approving what Congress does. I mean, one thing that's striking, though, if you put this in a larger context, is how big of an outlier those first few years of the FDR administration were. So the court really had never been as aggressive in striking things down as it was during those few years. It was striking down more laws. It was striking down more important laws. It was striking down laws much faster than it ever had before in American history. And it was at the same time hardly upholding anything that the New Dealers were doing. And so it really was setting up a kind of conflict between the court and Congress that was unusual, historically speaking, and not something the court had previously engaged in.
Yeah.
And it was short-lived.
Okay.
Dahl would have predicted it would be short-lived because, as he says, there's a time limit on how long judges can do this. If you have a stable political coalition, it will eventually outlive those judges and will replace them. And that's ultimately what happened during the New Deal period as well. But part of what's interesting about the New Deal period is that that initial replacement of the justices in the late 30s and early 40s led the court to be less aggressive in striking things down. But the court bounced back and pretty quickly discovered new doctrines, discovered new concerns it would have, and it started exercising judicial review again to try to restrict what Congress was doing, start nibbling away at congressional policy. And I think that process started much earlier than people tend to realize. People tend to emphasize what the Warren Court and the Byrd Court were up to in the 1960s and 1970s. And I think actually there's a lot more going on in the 1940s and 1950s than people tend to think.
There's a rights revolution.
Yeah.
But it's interesting. The rights revolution, it seems to me, it comes about precisely because the recognition that they've actually licensed unlimited government power, and so they necessarily have to find doctrines for rights. It seems there's sort of this paradoxical.
Part of what changes during this period is an abandonment of a lot of the structural doctrines that the court had previously spent a lot of time defending. So the court in the 1940s, 1950s, 1960s became much less interested in enforcing separation of powers concerns, much less concerned with enforcing federalism constraints on what Congress can do. But they really focused their attention on individual rights concerns and took that in new directions and took that more aggressively. It's not that the court had never cared about individual rights before. The court had also enforced individual rights prior to the New Deal. But after the New Deal, the court did tend to think about a different set of rights than what it tended to emphasize earlier in American history.
Thinking here, so part of a backlash, a later backlash, let's talk about the knuckle-dragging, benighted conservative court. What did you find here, legacies? What's the truth here about the conservative court? What does it actually achieve, if anything?
Well, I think the court in general is a less important player than I think some would want to give it credit for, or that others want to blame it for. It has, throughout its history, struck down statutes. Sometimes it struck down some very important statutes. But it, generally speaking, tends to nibble away around the margins of politics. The most controversial, the most important things that Congress has done all through its history, and that's true today as well as it was earlier in American history, the court tends to not get in the way of. And so the occasions when the court does get in the way and does strike some stuff down is very much the outlier. And the vast majority of what Congress does, even the very controversial things that Congress does, the court is mostly going to uphold rather than actually strike down. So as a consequence, as a substantive matter, the most important controversial political debates, the most important controversial constitutional debates are often occurring outside the courtroom rather than inside the courtroom in terms of actually determining what kinds of policies and values get cemented into American government.
So thinking here specifically, your analysis, how does sort of the empirical work you've done here, how does it inform how Keith Whittington thinks about judicial power, but constitutional interpretation, and the role of the judiciary in formulating that interpretation.
Yeah, so I think it's twisted in various ways. I began my career very concerned about normative theories about how the court ought to interpret the Constitution. My first book was a defense of originalism as a method of constitutional interpretation, and had a set of normative concerns about the court behaving in anti-democratic ways by enforcing a set of values and rules that people themselves had not actually agreed to. I don't focus specifically in this book on just how what the methods are the courts are using to try to interpret the Constitution. I think I may want to try to come back to that at some point. But the fact is, the court is heavily influenced by and has been over the course of its history, influenced by the particular values and concerns of its period. They're not always very careful. The justices are not always very careful about what the original meaning of the Constitution was and trying to identify it and enforce it. So, I think from a normative standpoint, then I think the court is probably has not always been exercising judicial review in quite the way that I would prefer. I think from a theoretical perspective, but also has not been, I think, as consequential as I might have worried about in my early normative work. Not as consequential as Alexander Bickel was afraid of, because the court, precisely because it is a mainstream political actor operating within the political mainstream, is not, for the most part, going to come way out of left field and do something particularly bold and aggressive. Instead, it tends to do things that are very much in keeping with what major party coalitions wanted the court to do. And so I think, to that degree, thinking about the progressive historiography of the late 19th and early 20th century court, for example, the progressives were just very disappointed about what the court was doing. They were mad about what both the U.S. Supreme Court but lots of other courts were doing at the time. But what the progressives tended not to emphasize enough is the fact that conservatives were winning elections. And so the reason why those courts were expressing those particular values is because the coalition that appointed those judges was the conservative coalition that mostly was winning elections. And so if you really want to change the direction of the court and push it in a different direction, if you want to see a different set of values reflected in American constitutional law, at the end of the day, you have to win elections. And at the federal level, that means both winning the presidency, but also ultimately winning the Senate.
Keith Whittington, thank you so much for your discussion today of your new book, Repugnant Laws, Judicial Review of Acts of Congress from the Founding to the Present. Thank you so much.
Thank you.
This is Richard Reinsch. You've been listening to another episode of Liberty Law Talk, available at lawliberty.org.